Yes. You did anything like
Thank you. Yes. Okay, I was just gonna order an Uber. It's going to Norfolk, so I don't think someone wants to drive me to Norfolk.
Okay, yeah, just let us know.
Yeah, thank you.
Okay, Jim, it should be live.
Okay.
Want to see if that's up?
Would it be up in the live pad? Yes, it
Uh,
is, it's up.
okay,
I'll check it.
okay.
Thank you. Okay, where are you sitting right now?
Grab me a seat. I should be relatively nearby in case the live stream goes.
Oh, so you don't wanna be on the other
No, like, just, I should be in the room.
I'll sit right here.
Okay.
This is gonna be, I think it can go right here.
The chair.
Yeah, for right now.
For right now, for sure. So you don't wanna be on the
No, like, just, I should be in the room.
I'll sit right here.
Okay.
This is gonna be. Yes, I've been informed.
Okay.
I can't go any further than that. Let's do that.
Yes.
Sit next to the mother. Wow. You got demoted. You have to be ready to fix the live stream.
I just didn't think that.
I didn't do that.
Yeah, he does. Yeah, I mean, did you? Yes. You want to go up here, so you're on stuff. You know. Oh. Oh, one of the competitors is not yet. There's tons of seats, just sit Did you get my voice? Did you tell him the lab? No. Okay, sorry. There's no more. He's in trouble.
All rise. The Honorable, the Chief Justice and Associate Justices of the Supreme Court of the United States. Oh yay, oh yay, oh yay. All persons having business before the Honorable, the Supreme Court of the United States are admonished to draw near and give their attention, for the court is now sitting. Chief Justice Biran and Justices Siler, Kelsey, Tyson, Barringer, Bissoon, Arrowood, Wood, and Broas presiding. God save the United States and this honorable court.
Good afternoon. Please be seated. We're ready to begin argument. Will petitioner's first counsel please begin?
Petitioner's over here, Your Honor. And we're reserving 1:30 for rebuttal from Mr. Upshaw's time.
Very well.
Chief Justice, Your Honors, may it please the court. My name is Megan Haddad, and I, along with my co-counsel, Mr. Austin Upshaw, represent the petitioner in this case, Officer Chester Campbell. I will be addressing the question on the motion to dismiss, and Mr. Upshaw will address the question on the motion to proceed in forma pauperis. For decades, the standard for failure to protect claims has been whether an officer has been deliberately indifferent to a substantial risk of harm. Deliberate indifference is a subjective standard. Yet the 14th Circuit held that an objective inquiry suffices, but this decision is both precedentially and prudentially incorrect. This court should reverse the 14th Circuit and maintain restraint in questions of due process for two specific reasons. First, precedent dictates that deliberate indifference is necessarily subjective, and Kingsley versus Hendrickson did not disturb this. Second, lowering the standard on failure to protect claims to an objective inquiry would threaten to turn due process into a font of negligence claims. Claims by prisoners and pretrial detainees generally fall into one of three categories. There's failure to protect claims, like the one here, in addition to failure to provide adequate medical care, generally speaking, omissions claims. There's also excessive force claims, and then there's conditions claims, which concern rules, regulations, policies, and practices.
On the continuum of those claims, why isn't the failure to protect claim much closer to an excessive force claim? We know that jails are very dangerous places, and why shouldn't we put this type of claim into the same bucket as the claim that was at issue in Kingsley, where we will, analyze these claims under an objective standard, and in this case, all that would require is, whether it was reasonable for your client to look at the notes in his pocket.
Kingsley versus Hendrickson recognized that the facts of different claims, even under the same amendment, do differ. In addition, Farmer versus Brennan specifically noted that the Farmer versus Brennan standard, which was developed with failure to protect claims in mind, specifically, Farmer versus Brennan noted that standard would be inapplicable in excessive force claims. So this court has recognized that differentiating between the different types of factual bases.
That's a post-conviction set, is it not?
That's correct, Your Honor.
Well, shouldn't we care that we're dealing with a pretrial detainee?
Yes, Your Honor, that does matter to the extent that the 14th Amendment does not allow any punishment. That we readily understand. That's Bell versus Wolfish's holding. However, as it currently stands right now, each of the court's three inquiries under failure to protect, under excessive force, under conditions claims, under the 14th Amendment, all have some element of intentionality to them. Removing that intentionality aspect from deliberate indifference and failure to protect claims would remove intentionality entirely from that inquiry and threaten to turn failure to protect claims under the 14th Amendment, as they stand right now, from a single intent inquiry into a zero intent negligence inquiry. So to go more into that, Kingsley versus Hendrickson, which was an excessive force claim, has two parts to it. First, an officer has to deliberately apply harm to an inmate, or to a pretrial detainee, excuse me. And second, that harm, the officer's application of the harm has to be objectively unreasonable. Prior to that, the second inquiry under Kingsley was whether the officer applied the harm with the intent to punish. However, the court recognized that that was a double intent standard and said in order for a pretrial detainee to be punished, there doesn't have to be double intent there. The single intent suffices. However, that logic does not apply to the failure to protect realm, and that's because—
the difference between commission and omission.
That's precisely the difference, Your Honor.
In tort law since time of Blackstone.
The difference between failure to protect and excessive force is precisely premised on that difference between an affirmative act and an omission in the failure to protect context.
So the follow-up question would be, should the due process clause and the protections that it seeks to aim at be calibrated differently than the Eighth Amendment, which has the same structural foundation, but a different target?
Currently, as it stands right now, the standard for deliberate indifference under both the 8th and the 14th Amendments suffices for both the 8th and the 14th Amendment. It does prohibit punishment by an officer, and as this court held in Wilson versus Siler, punishment is a deliberate act.
Yes, but I mean, excessive force in Eighth Amendment context heavily weights the deliberation part, the intentionality part, just by the very nature of the context. Due process isn't that focused on that first premise. It's focused mostly on results in process, right?
In certain situations, in the substantive due process aspect that is at issue here is whether the person's life, liberty, or property was deprived without due process of law, and that's where the due process comes in. However, this court in Bell versus Wolfish has noted that in order for something to be a violation of the 14th Amendment, where an omission is premised, is whether or not that is punishment. So Bell versus Wolfish did concern conditions claims, and Bell had a secondary holding, which was that a condition that does not rise to the level, or excuse me, a condition that is not rationally related to a legitimate governmental interest could run afoul of the 14th Amendment. But a condition is based on a policy or practice that has been deliberately implemented. So the objective inquiry in the conditions claim makes sense because there already has been a deliberate, intentional action on behalf of the institution in that situation. However,
Counsel, an omission can be deliberate, right?
it depends, Your Honor. It would be a fact-based inquiry.
I agree, but an omission can be deliberate, and it can also be intentional, right?
It could, if there was a situation.
So when you talk about deliberate indifference, that could include an omission. And it could be an omission that was made with either actual or constructive knowledge, correct?
Actual or constructive knowledge potentially, but depending on the actual or constructive knowledge, that may or may not rise to the level of a deliberate indifference constitutional violation.
But your client knew that this was a dangerous place, that there were lots of gang members in this prison, right? He knew that.
The jail officers do generally know that prisons and jails are dangerous places, Your Honor.
And he's worked there for a while, and he knows that, you know, the population of prisoners there are dangerous people. They're from rival gangs.
Correct.
So he knew that. That's not even constructive. That's actual knowledge. But then we get to constructive knowledge. He had that list in his pocket, which he claims he didn't look at. He ignored a meeting that he should have been at, didn't go to. He knew that there were gang members in the different cells, and yet he was called to go and put these people together. And he didn't take any steps to identify who these people were.
Your Honor.
And you don't think that's deliberate?
Your Honor, so while Officer Campbell's actions were certainly not commendable, all they amount to is a failure to take due care. As Your Honor said, failure to take certain steps. And a failure to take due care is at its core a negligence inquiry.
But this was more than negligence. Isn't there something between negligence and a total intentional act? Isn't there some other standard in there?
I'll speak to the two potential in-between standards that this court could adopt and why neither of them actually work in practice. So first, gross negligence. Gross negligence, as the Seventh Circuit noted in Salazar versus City of Chicago, is still just an error. And the purpose of due process is to guard against abuses of governmental power. And while an error is certainly not commendable, it's still just that, an error. An error is not an abuse of governmental power. And with regard to a civil recklessness standard, which
your client committed mere error?
Yes, Your Honor. Officer Campbell's actions aren't commendable, but this court has recognized that an officer's failure to take due care isn't a constitutional violation.
Did he not have a duty to engage in the practices and protocols of the office that he held?
Yes, officers do have a constitutional duty to provide for the safety of those in their care, but if this court were to establish a rule that says that every failure to live entirely up to that duty without the element of intentionality that currently lives in it, that would turn due process into a negligence inquiry. And negligence is categorically beneath the threshold of due process. Kingsley,
Is this at least reckless disregard?
reckless disregard is the standard that Farmer adopted, but this doesn't rise to the level of reckless disregard. So,
why not?
Yes, Your Honor. Leal versus Wiles out of the Fifth Circuit is particularly instructive on this matter. So Leal versus Wiles, the Fifth Circuit there noted that deliberate indifference is a high standard. And Leal versus Wiles had facts almost identical to the ones in this case. In that case, the plaintiff was a member of a gang, housed in a jail that also held members of a rival gang. An officer collected the plaintiff in that case, brought that plaintiff to the area outside of recreation. The officer collected another 2 inmates, also brought them to that same area, and attack happened.
What relief are you seeking here from this court?
We ask that the court reverse the 14th Circuit and hold that the subjective standard under deliberate indifference is the proper inquiry for 14th Amendment pretrial detainees, Your Honor.
Can I interrupt you there? I'm caught up in what seems to me to be oversimplistic distinction between subjective and objective. I thought, and correct me if I'm thinking incorrectly, that deliberate indifference was meant to be that awkward compromise between an intentional tort, so to speak, or a mere negligent tort, so to speak. Isn't that really the 3 categories we're talking about, as opposed to debating the boundaries, deliberate indifference or negligence?
Agreed, Your Honor. Deliberate indifference, the standard that Farmer versus Brennan articulated, did strike that balance. Farmer versus Brennan recognized, as I said before, that jail officials and prison officials have a duty to protect the safety of the people which the state has decided to constrain the liberty of. We don't dispute that. And deliberate indifference struck the balance between providing for that standard, but also recognizing that jail officials have very difficult jobs where they have to maintain institutional safety and security on a daily basis in a very dangerous environment. Deliberate indifference, as it stands right now under Farmer versus Brennan, strikes that standard and should not be lessened, because that would result, as I've said before, in an inquiry that essentially turns into negligence. And this court has recognized, specifically in Kingsley versus Hendrickson, which quoted County of Sacramento versus Lewis, that negligence is categorically beneath the threshold of due process. Turning again to the facts.
How would you comment on a willful blindness? Is that a standard too?
A willful blindness might rise to the level of a bad faith on the part of the officer, and that could potentially be a constitutional violation. However, the facts of this case don't demonstrate, have not alleged willful blindness on the fact of Mr. Campbell.
Did your client have multiple opportunities to verify the status of the pretrial detainee?
He did, but just because he had opportunities to verify it does not necessarily equate to the idea that he acted in bad faith and was willfully blind to these matters. So there is dispute on the record at pages 5 to 6 on whether or not Officer Campbell attended the meeting on January 1st. One indicates that he did, another indicates that he was sick and he called out. Not going to a meeting because someone is sick could hardly be considered a bad faith on their part. Officer Campbell may have reviewed the notes, but unfortunately the database has been wiped, so we don't have that information.
If we accepted your rule, wouldn't that be essentially adopting a willful blindness standard as the instruction to essentially jail staff? In other words, make sure you don't look at the notes in your pocket, because if you do acquire actual knowledge or enough, if you do know too much, you'll be liable. Whereas if you don't look at the notes, you'll be good.
Specifically only liable under the Constitution. So yes, in part, Your Honor. while an officer would only be liable under the Constitution if they had actually looked at the notes, there are other remedies that the respondent could have pursued. Respondent could have gone through the administrative remedies at the jail. Respondent could have availed himself of state tort law. Respondent could have sued the Benucci clan member that attacked him for battery. There are several.
I'm struggling with the semantics of this discussion because willful blindness, willful is some measure of intentionality. I'm willing or not willing. Deliberate indifference is exactly, they're just synonym phrases. They're synonymous. Why don't you just say, of course, willful blindness would be deliberate indifference? Well, we don't have that play here.
Sorry, Your Honor, that is what I'm saying. If I misspoke earlier, that was on me, and my apologies.
So if we go back and read the complaint, this went out on 12/6, is that right?
Correct, Your Honor.
So if we go back to the complaint, is there any reasonable inference from the complaint of willful blindness, which is, I'm not looking at this because I don't want to see what it says, as opposed to, I just blew it off, I wasn't thinking about it at all.
No, Your Honor. So on the record at page 6, it specifically notes that Officer Campbell did not know or recognize Mr. Shelby at the time that he went to collect him from recreation.
That's not the issue. The issue is, should he have, and if he deliberately chose not to find out, that's willful blindness. That's, frankly, I would say deliberate indifference is a matter of law.
Yes, Your Honor, I was getting to that. So Officer Campbell did not recognize that Arthur Shelby was potentially a member of this gang who was potentially at risk. If he had recognized Mr. Shelby or recognized that Mr. Shelby was a gang member, then that could be considered willful blindness by not checking the roster that he had in his pocket. A failure to take due care, a failure to take reasonable measures to abate a risk that he was.
What was the purpose of the list in his pocket?
The purpose of the list in his pocket was to list every single potential conflict among different inmates. We don't know actually how long that list was. It might have.
Presumably, he knew that the list in his pocket was an important list.
Yes, Your Honor.
Okay, and he chose not to look at it.
He might have forgotten. Choosing and not to look at something and forgetting are two different
Is there
inquiries.
anything in the record that says he forgot?
Your Honor, that record is unclear as to that point, and that this if this court does wish to remand to the district court on that point, that we would. I see my time has expired. May I briefly finish?
Yes.
Then we would be okay with the district court remanding to the district court on that specific question. But what we urge this court to do is to keep the subjective deliberate indifference inquiry. This court should reverse the 14th Circuit's decision on that matter. Thank you.
Thank you. Mr. Upshaw.
Yes, Your Honor. May I proceed?
Yes.
Chief Justice, Your Honors, may it please the court. My name is Austin Upshaw, appearing on behalf of the petitioner, Officer Chester Campbell. I'll be discussing Arthur Shelby's motion to proceed in forma pauperis. This case is about delivering clarity to the federal judiciary as it applies the Prison Litigation Reform Act's 3 strikes rule. Now, prior to filing this action, Arthur Shelby had 3 suits that he had filed dismissed against him pursuant to this court's decision in Heck versus Humphrey. And as a result, it triggered the Prison Litigation Reform Act's 3-strike rule, which says anytime a prisoner has had 3 or more suits dismissed against them for failing to state a claim, that they're barred from informa pauperis status.
Is a Heck dismissal a failure to state a claim?
Yes, Your Honor, for 2 reasons. First, this court, when it decided Heck versus Humphrey, created a pleading requirement that Arthur Shelby necessarily failed to meet every time he had a Heck dismissal against him. And second, the rationale behind Heck requires district judges presented with Heck-barred claims to dismiss all of them for failure to state a claim. I'll begin
But
first.
they're dismissed without prejudice.
Your Honor, this court in Lomax versus Ortiz-Marquez held that even dismissals without prejudice count as strikes under the PLRA. This court reached that conclusion by saying that whenever the court is determining whether a dismissal constitutes a strike, the analysis hinges exclusively on the basis for dismissal. And so even dismissals without prejudice, when they are for failing to state a claim, are strikes under the PLRA, according to this court. So yes, Your Honor, even Heck dismissals without prejudice are not strikes, but if a plaintiff brought a 1983 claim and the district judge gave them leave to amend it, that would not be a strike.
Is this a moot matter since he came in, brought the money? And
Your Honor.
Received, right?
No, Your Honor, not necessarily. The matter is not moot. Arthur Shelby could be entitled to reimbursement for those $400. Returning to the argument that Heck versus Humphrey created a pleading requirement, when this court decided Heck, it created a bright line rule.
It said every Section 1983 complaint which challenges the validity of an underlying conviction without first getting that conviction overturned must be dismissed. And that's this court's language, must be dismissed.
Without prejudice is the other part of that language, though, isn't it?
Not necessarily, Your Honor. Heck versus Humphrey did not weigh in on whether it was with or without prejudice. And even if Heck versus Humphrey did say that, it would still count as a strike. Because this court said in Lomax versus Ortiz-Marquez that dismissals without prejudice are also strikes.
Can I interrupt you there? So I'm with you that a 12b6 can be with or without prejudice, and if it's a failure to plead sufficient factual allegations, it's almost always without prejudice for a motion for leave to amend. But this statute, 1915G, says three different disjunctives: frivolous, or malicious, or 12b6 as a category. So isn't it telling us you can have frivolous, and every frivolous claim is going to be a 12b6able claim, but you can have a ton of 12b6able claims that are not frivolous. So doesn't that require us to go beyond simply the technical term of failure to state a claim and look at the context, which is really what the other side's asking us to do? It's not unpersuasive.
Your Honor, 1915G invites the district court to use any of those three criteria to count a strike. So something could fail to state a claim and it could be frivolous. There would be no question that would be a strike. But if something merely fails to state a claim without being frivolous, it still counts as a strike under 1915G. And we're asking—
Why do you ever need to say in the statute frivolous? Because everything that fails the 12b6, it doesn't matter whether it's frivolously failing 12b6 or just barely failed 12b6.
Your Honor, there's many frivolous claims which don't fail to state a claim under 12b6. These are independent categories. They're not necessarily one and the same. Something could—
An example of a frivolous complaint that would not be thrown out on 12b6.
If a prisoner, an example is there, you know, if a prisoner were to file a complaint that alleged the elements of Section 1983, but did not even make an attempt to support those elements with a single factual allegation,
That
and
would be 12b6.
no, Your Honor. Well, Your Honor,
You wouldn't throw it out on 12b6 if you were a district court judge.
Your Honor, a frivolous complaint might state I concede, Your Honor, that would be very uncommon. But the point is that 12b6 and frivolousness are independent grounds, and they would be analyzed on different grounds. So if a court were to find that something was dismissible under 12b6, it wouldn't follow as a matter of law categorically that it was frivolous.
But isn't this different than most situations? Let's just assume for the sake of argument that Heck spoke of the failure to state a claim. Isn't this a little bit different in the sense that we're really talking about when a claim accrues? At some point, this claim could accrue.
No, Your Honor, that approach has been taken by two circuits, the 7th and the 9th. This court should overturn those circuits. The ripeness approach is flawed because it undermines the core premise of Heck versus Humphrey. The 7th and the 9th circuits that have taken that approach have both held that the Heck doctrine is waivable. Now, that flies in the face of this court's decision in Heck. The decision in Heck was all about federalism. The idea was that if a Section 1983 complaint, which challenges the validity—
It wasn't about federalism, it was about a basic concept, which is a cause of action that's got to accrue before you can bring a breach and a damage claim.
Your Honor—
It's not accrued, it's not right.
Your Honor, the extent to which it is about federalism, Heck versus Humphrey is about protecting the procedural safeguards of federalism in the following context. If a Section 1983 complaint seeks money damages for an invalid conviction, and that district judge weighs in on the validity of the conviction before state courts have had the opportunity to review the conviction in collateral proceedings, or before a federal court sitting in habeas corpus jurisdiction has heard it, none of the doctrines of deference to state courts that are supposed to apply when state convictions are questioned are applying in the 1983 context.
Well, one of what you're saying implicates possibly another way to approach a case that could potentially be dismissible under Heck, and that's to abstain under the Younger doctrine. Some courts do that, correct?
Yes, Your Honor.
And if that's the case, and if there are two alternate courses that a court can take, why, if they dismiss, should that count as a strike when another litigant over here, where a court decides to abstain, may get favorable termination and the cause of action may then come back and be heard? It seems to me that if there's a way, if some courts can deal with a case without leading to a very serious repercussion, it seems to me that the dismissal under the same rationale shouldn't be considered to be for failure to state a claim.
Your Honor, the reason that this court should take the pleading requirement approach is because this court in Heck reasoned by analogy to develop that favorable termination requirement. And it reasoned by analogy to a common law claim for malicious prosecution. What this court explained is that a 1983 suit seeking damages for wrongful conviction is essentially the same as a common law claim for malicious prosecution. And the language this court used to draw that analogy is very important. This court noted that in the malicious prosecution context, one element that must be alleged and proved is favorable termination. That's this court's language.
Have we ever held that a district judge can abstain in a case like this when there's a pending 12B6 motion that under our precedent would require to be decided and the case dismissed?
Your Honor, I don't know of a case that holds that proposition.
Have we ever said in any of our various abstention doctrine cases that a case should be abstained when the 12B6 is valid on its face?
Again, Your Honor, I'm not aware of any cases that stand for that proposition, but the abstention doctrine route is the wrong route for this case because the pleading requirement route makes more sense. And there's 4 circuits that have followed this approach. The DC Circuit, the 3rd Circuit, the 5th, and the 10th have all read Heck versus Humphrey to do the thing that it most naturally is read to do.
What do you understand the reason, what do you understand the purpose of the PLRA to be?
The purpose, as this court has noted, is twofold. First, to decrease the quantity of suits within the federal courts, but to increase their quality. And that's best effectuated on the reading of the PLRA that we're asking this court to adopt now.
How does this argument that you're making fit into the purpose of the PLRA?
Yes, Your Honor. In this situation, Arthur Shelby had 3 suits dismissed pursuant to the Heck bar. That means that in 2 instances, Arthur Shelby had the opportunity to revise his claim or to not bring an improperly pled Section 1983 claim again. The purpose of the PLRA, best applied here, is to bar informa pauperis status going forward, given that he's met the criteria that Congress chose was the right amount. Congress...
Prior actions don't have to have a thing to do with this particular case, do they?
Your Honor, 1915G requires that they do. 1915G places a duty on every federal court. It deprives them of the ability to grant informa pauperis status. So Section 1915A, in the first instance, gives district courts broad discretion to grant informa pauperis status. It says they may.
Were the first 2 strikes throwing out 1983 cases challenging the legitimacy of the conviction?
Your Honor, the record does not say. The record is silent as to what the grounds were.
It would be a big deal if this is 3rd at bat and he's doing the same daggone argument that we told him twice you can't do.
Your Honor, I agree. That would go more to the frivolousness inquiry. But the reason that we know everything we need to in this case, even given how little we know, is that because the record tells us at page 3 that all 3 of his prior suits were dismissed pursuant to Heck, it tells us 2 things about all 3 of them.
But doesn't that answer my question? If they're dismissed pursuant to Heck, that means he must be bringing a 1983 case challenging his conviction that no court has said was invalid.
Yes, Your Honor, we agree. Yes, that's why they count as strikes.
Right, so why would anyone abstain to the 3rd case?
I'm not sure I understand the question, Your Honor. All 3...
These are all favorable questions, by the way.
Yeah, I'm agreeing. These 3, they're all strikes.
Well, try harder to understand that.
You got it, Your Honor. All 3 count as strikes because in all 3 instances, he had not yet achieved favorable termination and he failed to plead it.
If that's true, how could any pretrial detainee have a favorable termination that they're presumed to be innocent? They don't have the connection.
Your Honor, it goes to a fact question of whether they've achieved favorable termination.
Then that should go back to the trial court, not be decided by an appellate court.
Well, in this instance, there's been 3 prior dismissals that were not in this district court. So what matters, what the district court applying 1915G has to do is they have to look at the dockets for those 3 courts. They need to look at the opinions and the orders dealing with those dismissals, and they have to look at how those district courts resolve those claims.
Where does this favorable determination element come from?
Anytime, as Heck explains, if a conviction has been overturned by a state collateral proceeding, it counts as favorable termination. If a habeas court has...
I'm asking you where this requirement that you seem to suggest is an element of the claim, where does that come from?
It comes from Heck versus Humphrey. That's the phrase that Heck versus Humphrey used to describe it. It called it a favorable termination requirement. And what it means is that the plaintiff, and to use the words of Heck, this court's words,
So
must...
it's not a part of any statutory analysis.
Well, Section 1983 is the statutory source of the 1983 claim,
Right.
but Section 1983 in the statutory text doesn't say element 1, element 2, element 3. Courts elucidate the elements of a claim based on the text. Favorable termination is based on the text of Section 1983.
So Heck is a judicially created doctrine and is not actually found within the statute itself.
Your Honor, it's a judicially created doctrine, but it's based on the text. It's based on just like the elements of, so there's two elements of Section 1983 that will apply in any 1983 case, regardless of the factual allegations. First, that the defendant acted under the color of law, and second, that the plaintiff's constitutional rights were violated. But anytime a 1983 suit seeks damages for a wrongful conviction, the court in Heck said they must allege and prove favorable termination. So yes, Your Honor, it is judicially created. Now, if Heck was the wrong rule, this court can overrule itself, but that's a different question for a different day. We'd have to submit supplemental briefing on that. That's just not the question that's been presented today. That's the rule that this court adopted.
Is it significant to your claim that all three dismissals were Heck barred? So in other words, would your argument be different if, say, two of the dismissals had been frivolity?
No, Your Honor, and that's because Congress made the determination that 3 strikes, no matter the grounds, count as barring from informal pauperous status. But just to say a word about the rationale behind that kind of decision, if a prisoner has had 2 strikes against them, they should be on notice about it, and it should affect their behavior as they do a third filing.
It just affects them to pay the money up before they take the appeal, though.
If they're
They can
denied,
still appeal, they just have to shake out the money.
that's exactly right, Your Honor. The Arthur Shelby's denial of informal pauperous status has not barred him from the courtroom today. The merits of his case are being heard because he did pay the money. Your Honor, I see my time has expired. We ask that this court reverse the 14th Circuit. Thank you.
Thank you. We'll hear now from the respondents.
May I proceed?
Please.
Chief Justice, Your Honors, may it please the court. My name is Jody Lessner, counsel for the respondent. Today I will be arguing the deliberate indifference question. My colleague Ben LaRude will be arguing the informa pauperis question. Arthur Shelby's 14th Amendment rights were violated when a corrections officer failed to protect him from a violent assault perpetrated by members of a rival gang. The duty that is owed to pretrial detainees like Mr. Shelby is an objective one, in accordance with this court's holding in Kingsley versus Hendrickson. I will first explain why the objective.
It was an excessive force.
Yes, Your Honor.
And it was a splintered opinion. And by one vote, it became law and is law. It is law today before us. But you're asking us to extend this idea, this new mens rea idea, to something that is essentially a omission type of tort, as opposed to a commission, beating somebody up with excessive force. What's the basis for doing that, other than citing us back to the case that is not directly on point?
Your Honor, the 14th Amendment is what applies to pretrial detainees and not the 8th Amendment, because 14th Amendment detainees have not yet been judged guilty of any crime. And therefore, the 14th Amendment affords greater protections than the 8th Amendment.
In Kingsley, by a 4-3 vote, we extended it to excessive force. It was a split opinion. It was a divided case. It was a hard case, which is why we splintered the court on it. But it was an affirmative excessive force case. It was not a negligent failure to protect case. Why would we push one more direction in that vector when the only rationale we get is that we're dealing with 2 different provisions of the Constitution?
Your Honor, I have 2 responses to that question. The first does go back to the constitutional amendments that afford the protection to these detainees. While the claims themselves might be different, Kingsley, you're correct, involved excessive force, and this is a deliberate indifference claim that doesn't change the underlying constitutional right that protects them. And lower courts.
There's due process.
Yes, Your Honor.
And it's specifically not procedural due process, it's substantive process.
Yes, Your Honor.
Which is itself a debatable doctrine among the 7 of us. You know that.
Yes.
Why do we want to push in that direction?
Your Honor, creating an objective standard that applies beyond just the excessive force claim would create a uniform standard that would apply for all pretrial detainees and would make officers' jobs easier. If there's one duty that can be applied to all pretrial detainees, officers who are placed in difficult situations, who have to make split-second decisions about what their actions are going to be in given circumstances, they'll have one duty of care that they have to apply to pretrial detainees. There'll be no parsing.
It's not a intentional act. That's what you're advocating, right?
No, Your Honor, we're advocating for an objective standard, which is a step above negligence. We recognize that this court has consistently held that negligence is below the threshold of a constitutional violation. The objective standard instead would require that the plaintiff prove first that the officer disregarded serious risks to the inmate's safety. He failed to protect him from
Negligently disregarded it, or willful ignorance, willful blindness, we would say.
The negligence would be a generalized breach of duty, whereas the objective inquiry would be fact-specific. He knew something, and he failed to take steps that would have limited that risk.
That seems circular to me.
Your Honor, under an objective inquiry, we can measure the officer's behavior based on another officer in a similar situation who would have known similar things
That's
in
what
order.
we do in tort law every day. That's the negligence standard, the reasonable man standard. If Dean Prosser were here today, he'd say that's exactly what negligence is.
Your Honor, the negligence standard that has been applied and that has been rejected by these courts relates to the generalized breach. This side concedes that accidents, mistakes, those do not rise to the level of a constitutional violation.
How can you ever have an omission be more than negligence?
Your Honor, it's when the omissions accrue. It's when the officer had significant knowledge of the circumstances and of the risks that were posed to the inmate and failed to take any steps to limit that risk.
Access to the risk or sufficient as opposed to actual knowledge of the risk?
Your Honor, I believe it would be access to the risk that would have amounted to actual knowledge had the officer taken the steps to look at that information.
And that's an omission. That's something he failed to do.
Yes, Your Honor. That's the premise.
How is that different than negligence? I guess I'm just trying to understand. I mean, an accident or a mistake may or may not be negligence, but what you're describing here is someone is owed a duty and they fail to do something in accordance with that duty. And that is not negligence?
Well, Your Honor, it rises above a level of negligence because it's compared to the fact-specific context in another officer who was in the same circumstances.
Like a reasonable man. That's what negligence is.
Yes, Your Honor.
Well, hasn't the court already found that is even unknowingly failing to act, even if a reasonable person would have acted, that in and of itself still is just negligence.
Your Honor, I believe that what you're referring to are cases that have come before this court, such as Farmer versus Brennan, where that holding was, but that was an Eighth Amendment analysis that applied and not the 14th Amendment. The Second Circuit has stated that there's a difference in how we should evaluate deliberate indifference claims based on what constitutional protection is afforded. Under a 14th Amendment analysis, that subjective component of the officer's sufficiently culpable state of mind that's outlined in Farmer versus Brennan need not be met because they only.
So you're saying that in a facility that houses both pretrial detainees and inmates, there should be two different failure standards. If you're an inmate, Farmer versus Brennan applies to you, but there should be greater protection for the person in this next cell over.
Your Honor, yes. Frankly, because of that constitutional violation, the constitutional protection that's afforded. However, like it was in the case here to a more.
Why this fact that we're using a judicially created doctrine, substitute process, in the 14th Amendment instead of the very doctrine, excessive, cruel, and unusual punishment. That's the doctrine applicable to these kind of problems, where the framers were really focused on the issue of what do we do with people that we treat them poorly when they're in custody.
Your Honor, it goes back to the first principles of the population that we're dealing with here. These are people who have not yet been judged guilty of any crime. And so the Constitution says that they cannot be inflicted any undue punishment because no one has yet found them guilty. And although that rule doesn't advocate for people who have been convicted to be subjected to punishment.
It was just negligence. How did they get punished? Punishment requires some intentionality. You can't accidentally punish somebody.
Your Honor, in Farmer versus Brennan, the court acknowledged that intentionality isn't necessarily a required component, that if the plaintiff is able to show that the risk was so obvious that a risk would occur, that harm would occur, that intentionally sufficiently culpable state of mind that goes beyond, the sufficiently culpable state of mind that is behind the intentionality.
It's just deliberate indifference, which is what they're arguing for, and you're not arguing for it.
Your Honor, we are arguing that this is a deliberate indifference claim. We're just arguing that it's an objective standard that should apply in the evaluation because this is a pretrial detainee who's governed by the 14th Amendment and not the 8th.
So we should be using deliberate indifference cases to define the mens rea state of mind in your case?
Yes, Your Honor.
If it's deliberate indifference, where's the deliberation in your standard?
Your Honor, the deliberate portion of this comes from the numerous facts that were presented to Officer Campbell that he disregarded, the numerous notices of risk.
Against an act of omission, correct?
Yes, Your Honor.
Yeah, all of them, 5, 10, whatever there was, they were all failures to act.
Your Honor, not necessarily. On page 5 of the record, it indicates that after Mr. Shelby was booked, there was a meeting that was held for all of the officers to inform.
This officer was not present.
The officer was not present, but he had an affirmative duty to read the notes from that meeting. Now, the record.
Know what they say, did we?
Yes, Your Honor is correct. Now, I can respond to that in 2 parts. The first is, even if we assume that he didn't read those notes, he was holding in his hand a notice of the gang status, and there were placards and records posted around the facility as indicated on page 6 that stated that gang status. However, if the record is unclear about what Officer Campbell knew, all facts must be construed in favor of the plaintiff, and this case must be remanded back to the district level for further fact-finding, so we can assess what he knew, what he didn't know, if he read those notes.
Are you saying that you win under either standard?
Yes, Your Honor.
So why are we debating between Farmer and Kingsley?
Your Honor, we're debating between Farmer and Kingsley because, like I've mentioned before, the fundamental constitutional right that applies, that differentiates a pretrial
If we didn't
detainee.
have Kingsley, you would win this case under Farmer.
Yes, Your Honor. We would win this case under Farmer, as I mentioned, because of Farmer's text that states that the obviousness of a risk can serve as a type of substitute for the sufficiently culpable state of mind that Farmer outlines. And that's been applied in the Third Circuit in Kedra versus Schroeder, which held that the obviousness of the risk, in that case, the facts were specific to a person who didn't check to see if their gun was loaded before they fired it at someone. And the court held that the safety checks that an officer would have to undertake before they fired a gun were so obviously would present a risk that they didn't necessarily have a sufficiently culpable state of mind when they pulled the trigger, but it was so obvious that putting a loaded gun or not a loaded gun in front of someone, you would need to check to see beforehand.
When it was a loaded gun, it was an actual loaded gun, not a failure to check, correct?
It was a failure to check, Your Honor.
So it wasn't the result though was the fact that it was fired.
It was fired and there happened to be a bullet in the chamber that he did not know about. But if he had checked, if he had recognized that a firearm poses an obvious risk, that a responsible firearm owner would have checked to see if there was a bullet in the chamber before they fired, they would have known not to do so. There was the obviousness of the risk, even though there wasn't a sufficiently culpable state of mind. That's another element that can be used to prove a deliberate indifference claim.
Why should we care more about the nature of the detention rather than the nature of the alleged violation under 1983?
Your Honor, it comes down to the differences in the way that we treat different people. I don't mean to beat a dead horse here, but people who have not yet been found guilty of a crime are afforded different protections. They are presumed to be innocent.
But there are also differences in the types of behaviors that are being alleged here. One being intentional, the other being a sin of omission, let's just say.
Mm-hmm.
And if we accept your analysis, it seems to me that it is unavoidable to have under that umbrella negligent activities, conducted under Section 1983 that would be actionable.
Your Honor, Kingsley was concerned with this very same question when it was deciding whether or not the objective standard should even apply in the excessive force context.
Why it's 4-3.
Which is why it's 4-3, you're right, Your Honor. But perhaps in a concession, Kingsley was written in such a way to say that officers who are acting in good faith are still going to be protected, which moves them beyond a state of just negligence. If you're acting in good faith, you're able to further the penological interests of the facility to make sure that there's order, that there's discipline, that you're following orders and procedures. None of that happens here. Officer Campbell clearly was not following correctional facility procedures when he didn't attend the meeting, didn't read the notes potentially, even if we disregard those because they're unclear factually on the record, didn't look at the notes in his hands, didn't look at the placards around the facility. He wasn't acting in good faith, and therefore he doesn't deserve the protection that's afforded under Kingsley to those types of officers.
That's your case. You have to concede there are other cases that aren't your case.
Absolutely.
That may be of a lesser degree of, let's just use the word negligence, that presumably would fall under your standard. How do we account for that, and what do we do about that?
Your Honor, those are all fact-specific inquiries that would have to be analyzed based on what the officer knew, what the officer didn't know, based on the circumstances of the situation. But what remains is that the rule that opposing counsel is advocating for would leave officers with a very simple defense. They just have to plead ignorance.
Can I ask you this? Are you saying that Kingsley was a deliberate indifference case?
No.
Okay. So what does Kingsley add to Farmer? And why do you think you can win under Farmer as well as Kingsley? And why are we arguing about Kingsley?
Your Honor, Kingsley differentiates itself from Farmer because it applies in the 14th Amendment context. This court has never held that the subjective standard applies to pretrial detainees.
Sorry to interrupt you again, but I think I misunderstood you earlier. Are you saying that the proper standard for us to apply in your case, forget Kingsley, Farmer, and every other case we talk about, your case, is deliberate indifference?
Yes, Your Honor, we're saying that a deliberate indifference claim should be evaluated objectively. However, even if this court were to choose to use a subjective standard in evaluating that deliberate indifference claim, Mr. Shelby's claim should still be allowed to proceed. And for the foregoing reasons, I ask that this court affirm the 14th Circuit and apply an objective standard to a pretrial detainee's claim. Thank you.
Thank you. Mr. Moot.
May I proceed? Yes. Chief Justice Biran, Your Honors, and may it please the Court. My name is Ben LaRude, counsel for Respondent, and I will be arguing the in forma pauperis question. Respondent Arthur Shelby suffered life-threatening injuries under the watch of Petitioner. He now justifiably seeks to assert his constitutional rights in forma pauperis, invoking a long-standing benefit of our justice system designed to provide dignity and federal court access to plaintiffs.
Paid the filing fee under protest?
Your Honor, yes, the record states on page 7 that he did pay the fee for the district court proceeding, but footnote 2 on page 13 of the record notes that he is currently proceeding in forma pauperis for this action on appeal.
Or did he pay under protest, objecting to it, and did the court accept his payment under protest?
No, Your Honor, he paid the fee as the court requested, as the district court required.
We've not discussed it yet, but there is a doctrine of law called voluntary payment that waives claims against payments like this, as a matter of fact, if it's not paid under protest.
Your Honor, the question that we're addressing is whether the Heck dismissal categorically constitutes a strike such that it can then later be used to bar any plaintiff from filing in forma pauperis under the 3 strikes provision. Petitioner argues that categorically Heck dismissals are a failure to state a claim, but I'm arguing that this court should uphold the 14th Circuit's decision and the integrity of in forma pauperis for 2 reasons. And that is, 1, that Heck versus Humphrey established an affirmative defense, not a pleading requirement, such that a Heck dismissal does not indicate categorically a failure to state a claim.
How does accrual of a cause of action ever be categorized as an affirmative defense that only the defendant can raise it, and if he doesn't raise it, it's waived? Either the cause of action is accrued, that is, it's right, it can be adjudicated, because if it hadn't accrued, the court doesn't have jurisdiction even to decide the case.
Your Honor, I agree that the accrual issue indicates what the Ninth Circuit has held, which is that Heck dismissals are a matter of prematurity, of whether a claim has been brought prematurely. On the contrary, the Heck court, when it considered favorable termination, it was looking at considerations of judicial consistency and judicial finality about the possibility of a collateral attack. This is an inquiry that comes into play after a sufficient cause of action has been stated, which is why it makes more sense to consider it an affirmative defense, something that comes into play once a sufficient claim has already been made. And this is also why, therefore, failure to address favorable termination within the complaint does not indicate that one has failed to state a claim.
Can Mr. Heck bring countless claims that are dismissed under HEC without ever incurring a strike?
No, Your Honor, there absolutely are instances where a HEC dismissal will be a frivolous claim or where one might fail to state a claim.
And how many then would we have to bring in order to achieve that number?
It would be the 3 strikes rule, but whether or not a HEC dismissal is frivolous or does fail to state a claim is necessarily a fact-specific inquiry. So the rule that petitioner is arguing for is that as a categorical matter, HEC dismissals indicate a failure to state a claim, and that would just be an overly punitive rule that would...
So if we brought 9, for example, and each of them did not count as a strike, you're saying at some point we would get into the world of frivolity.
Your Honor, yes. Cochran versus Morris in the Fourth Circuit stated that past litigious conduct can play a role in understanding whether an action is frivolous or not. So there is a point at which, sure, it will be clear that a plaintiff is trying to abuse the justice system in some way. A study that was conducted shortly after the PLRA was passed indicated that in reality, only 90.5% of incarcerated plaintiffs that are bringing claims in forma pauperis file only 1 to 2 actions. So there's a small number of plaintiffs that are going to be of the type that you're getting at, which would be bringing numerous claims to the point that it would be clear that there's something else going on.
But you could see that there have already, in this case, been 2, so it's not as if Mr. Shelby is unacquainted with HEC.
Yes, Your Honor. However, the record states on page 3 that the 3 prior actions that we're dealing with here, one was filed against state officials, one was filed against prison officials, another was filed against the United States. The breadth of Section 1983 and the number of the different types of constitutional violations that it could be addressing indicates that these could have been very different claims addressing very different types of constitutional violations.
So what the statute we're talking about is very specific. 3 strikes are dismissals because of 1, frivolity, Rule 11, 2, maliciousness, or, not and, or 3, failure to state a claim. That's 12b-6, that's Rule 56 if there are no material facts. There were 3 prior 12b-6s. Why are we talking about this any further than that?
Because, Your Honor, the record doesn't state that there were 3 prior 12b-6s. There were 3 prior HEC dismissals, but HEC dismissals are not the same thing as the failure to state a claim that you'll see in Rule 12b-6. And the reason for that is...
Does HEC say that it is?
No, Your Honor. No, Your Honor. It just says that favorable termination is a grounds on which a court may dismiss an action if they notice that the civil action might call into question an underlying criminal proceeding. But
well, if the case is premature and it's not timely, doesn't a dismissal based on prematurity equal failure to state a claim? It's not right. The case can't be adjudicated. There's no claim to adjudicate because it's premature.
No, Your Honor. So the HEC court was looking at the prematurity issue, which is an inquiry into whether the court is the right court to be addressing the claim in this moment in time, but that doesn't have any bearing on whether the plaintiff stated a claim about a constitutional rights violation. So those are 2...
Saying there's something different, there's a mechanism to dismiss a case that is not a 12b-6 mechanism that is somewhere in our federal rules that speak to HEC, that's some separate thing that isn't a 12b-6 dismissal?
Your Honor, the Ninth Circuit in Washington versus LA County Sheriff's Department noted that a HEC dismissal very well could indicate a failure to state a claim if the failure to address the affirmative defense of favorable termination is obvious on the face of the complaint. So it is possible that these things can be the same, but it necessarily requires looking at the facts of a particular complaint.
Why don't we just look at the orders? What are the 3 orders that we're talking about? What were the orders from the district judges on these 3 strikes?
Your Honor, the record doesn't contain much information about them. It only states that they were dismissed pursuant to HEC because the court determined that there might be a conflict between the civil action. The record doesn't say, and that's why, as a categorical matter...
Suppose they were dismissed prior to trial entirely on the pleadings. Just suppose that don't concede it. What would that mean for us?
If the complaints were dismissed prior to the proceedings, it may indicate that there was a very obvious failure to state a claim that they might have been frivolous. In which case, they're
not frivolous. It's 12b-6 is not frivolity.
Yes. So there might have been a failure to state a claim that could constitute a strike, would constitute a strike under the PLRA. What I'm saying is that petitioners rule that categorically heck dismissals are always a failure to state a claim is incorrect.
Can I ask you, your position is that it's an affirmative defense. Congress, basically, if I'm understanding correctly, which can be waived, you're saying that Congress ceded to defendants on a case-by-case basis whether something would be a strike or not?
Your Honor, Congress laid out in the PLRA, the three strikes provision, that the three grounds for the strike, which we've mentioned, the frivolous, malicious, and failure to state a claim. But the PLRA was passed 2 years after Heck, and it made no mention of favorable termination. It made no mention of the need to address affirmative defenses. So there are grounds on which strikes can be attained, but it's just not specifically the Heck dismissal grounds of the favorable termination issue.
We said in Heck that a dismissal of a claim is not cognizable and that the cause of action doesn't exist until there's been favorable termination. How is that consistent with it being an affirmative defense that can be waived by the defendant?
Yes, Your Honor. The language that you're referring to gets to the point that petitioner made about looking to the tort of malicious prosecution, and that's where they got this idea of favorable termination. But that doesn't require that this is necessarily an element. The tort of malicious prosecution is a much narrower type of claim where a plaintiff is challenging the proceedings of the prosecution and whether that led to a conviction or a sentence. But Section 1983 is something much broader. So just because
the favorable termination element serve the same purpose?
It does, Your Honor, but it's not a pleading requirement as petitioner is arguing for every Section 1983 claim.
1983 is like 15 words. We've incorporated enormous amounts of common law into 1983, including all the immunity doctrines. Suppose we were to take judicial notice of 3 strikes here and go back to our chambers and look up the orders that are published orders by courts of this nation. And we found that all 3 of the orders were 12b6. What would be the conclusion we would draw from that, or should draw?
In that situation, there would be 3 strikes. 12b6 dismissals, 3 of them would be failures to state a claim, which would be a strike under the PLRA.
So are you proffering to this court at this stage that if we go back and look at that, we won't find that?
I'm proffering that as a categorical matter, the question at hand is whether this is a categorical issue, if heck dismissals always equal a failure to state a claim.
It's not the time for advisory opinions, it's the time for finding out whether your client is right or wrong, and the burden's on you at this point.
Yes, so remanding to understand more the grounds for the district court's dismissals would make sense in that instance. What we're arguing is that this court does not expand the rules of civil procedure, the pleading requirements. Rule 8A.
Several courts have held that a heck dismissal equates to a Rule 12b6 dismissal. Have they not?
Yes, Your Honor. There are several courts.
You're telling us not to agree with those courts.
I'm telling you to agree with other courts, the 7th Circuit and the 9th Circuit, which recognize correctly that claims that are dismissed pursuant to heck are very well, possibly meritorious claims that have simply been brought prematurely. The 9th Circuit in Washington versus LA County Sheriff's Department called it, quote, judicial traffic control, that's what the heck doctrine is.
Well, that was a little too cute by half for me, because it's a statute. It's not judicial traffic control, it's a statute, and it says basically failure to state a claim, and you got 3 of them, there's no informal part. So I don't know that the 9th Circuit was helping its cause so much with that rhetoric.
Excuse me, to be clear, they were calling judicial traffic, the language of judicial traffic control was referring to the heck doctrine, which is judicial, not to the PLRA. The PLRA is statutory, and it fails to mention favorable termination and the need to address affirmative defenses in order to satisfy the strike criteria.
So our opinion from the 9th Circuit's point of view was just us directly traffic in the federal courts when we incorporated a common law concept into 1983 like we've done dozens of times.
The court, excuse me, can you restate your question?
I question whether that locution of the 9th Circuit is a fair one.
Okay, yes, well, Your Honor, another thing that might be helpful that the 9th Circuit did is they likened favorable termination to administrative exhaustion, and I think maybe that's a helpful comparison to understand how they're treating favorable termination. Both favorable termination and administrative exhaustion are looking at whether a plaintiff perhaps could have should have sought recourse in another forum before bringing this particular Section 1983 claim.
So this is another place where maybe the 9th Circuit's just a little bit off off to the side here compared to where we are, because in heck, we said we do not engraft an exhaustion requirement upon section 1983, but rather deny the existence of the cause of action. Seems like we were doing something totally different than what the Ninth Circuit maybe thinks we were doing.
So the Ninth Circuit didn't engraft an exhaustion requirement either.
They're analogizing to it, and that's not a good analogy.
Okay, yes, Your Honor, that may be the case. I think what's important is just to note that there is a similarity, which it might not be dispositive, but the similarity is that in both administrative exhaustion and favorable termination, a court is looking at whether there should be another forum in which the plaintiff is seeking recourse. And this court in Jones versus Bach stated that exhaustion is an affirmative defense. And so I'm arguing that it would be odd to treat, given the similarity of the considerations that courts are making when they think of administrative exhaustion and favorable termination, that it would be odd to treat one as an affirmative defense and another as a pleading requirement.
Well, if there's not exhaustion, I mean, there are remedies the court can, or there are things the court can do. They can stay the case until it's been exhausted. That's not what happens in the context of heck.
Your Honor, that's correct. That's correct. There are a number of ways in which courts can respond. The fact of the matter is courts are making quite nuanced determinations about how to proceed, and I'd like to bring this to the plaintiffs that are making these claims. These are indigent plaintiffs filing pro se who don't have the legal expertise to be able to anticipate exactly how courts are going to respond.
And they get 3 shots, right? You get three chances.
Yes, Your Honor. The breadth of Section 1983 means that there are a wide number of claims that one might bring, such that one might bring 3 claims and have them all dismissed on heck grounds, and yet all these claims are very different. It doesn't necessarily mean that they're making the same claim over and over and over again. It's important to consider that the rule that petitioner is advocating for would curtail plaintiffs' ability to bring Section 1983 claims and to proceed in forma pauperis. These are 2 incredibly important and very historic tools that are afforded, if I may briefly conclude, that are afforded to plaintiffs that are filing from the confines of prison, and this court should not undermine those in a backdoor way, which is why we're asking this court to uphold the 14th Circuit. Thank you.
Thank you. Rebuttal?
Yes, Your Honor. May I proceed?
Sure.
On the Heck versus Humphrey issue, the respondent defends the Ninth Circuit's position by relying on the administrative exhaustion analogy. But that's wrong because administrative exhaustion requirements are about promoting judicial efficiency. But as opposing counsel notes, Heck's favorable termination requirement is about promoting judicial consistency, ensuring that habeas courts and 1983 courts aren't saying different things about the same underlying claims. The analogy does not hold up. And the respondent resists the closer analogy, which is that Section 1983, as this court said in Heck, is just like a malicious prosecution claim. Now, respondent just stated that malicious prosecution is a narrower claim than Section 1983, but that's not the case. They're the same underlying claim. Both of them are claims for money damages based on a wrongful conviction. This court in Heck said that malicious prosecution is the closest analogy. And that shows the problem with the affirmative defense approach. By treating Heck versus Humphrey's bar as an affirmative defense, it puts the hands in the defendant of what Heck says is in the hands of the district court. And the district court does not have discretion under Heck to waive that. It does not say the district courts may dismiss Heck-barred suits. It says they must dismiss them. It's not a discretionary or waivable doctrine. It's a requirement that's placed on all 1983 courts when they're presented with Heck-barred claims. This court should reverse the 14th Circuit. Thank you.
Thank you. Case is now submitted. Thank you, everybody.
Thank you, members. All rise. This court will stand in recess, and justices can follow me to the deliberating room.
Stay here.
We go.
Okay. They stay at the end.
Oh, yeah, there is.